Barangay Protection Order. Application shall be filed with the barangay where the applicant reside, may include the place where the victim survivor temporarily reside, or where the suit refute sanctuary to escape from and avoid continuing violence from the respondent. The punong barangay should issue the Barangay Protection Order on the date of filing of the application after ex parte determination of its basis. If the punong barangay is not available, the application for the Barangay Protection Order shall be acted upon by the available barangay kagawad. Barangay Protection Order. Immediately after the issuance of an ex parte barangay protection order, the punong barangay or barangay kagawad shall personally serve a copy of the same on the respondent or direct any barangay official to effect its personal service. Within 24 hours, after the issuance of Barangay Protection Order, the punong barangay, or in his absence or inability, any available barangay kagawad shall assist the applicant in filing a petition for a temporary or permanent protection order with the nearest court in the place of residence of the victim survivor.
Barangay Protection Order must be recorded in the Violence Against Women and Children logbook. The logbook is confidential and must be kept from the public, especially the media. A quarterly report of all Barangay Protection Orders must be submitted to the local office of the DILG. This department shall submit a summary report of the Barangay Protection Orders issued to the Secretariat of the Interagency Council on Violence Against Women and their Children. Reliefs granted under Barangay Protection Order. The Barangay Protection Order shall direct the offender to desist from causing or threatening the cause of physical harm to the victim. Effects of violation of Barangay Protection Order. Violation of Barangay Protection Order shall be punishable by imprisonment of 30 days without prejudice to any other criminal or civil action that the victim survivor may file for any of the acts committed. The punong barangay or kagawad who issued the order must file a complaint directly with any MTC that has territorial jurisdiction over the barangay that issued the order. If the punong barangay or kagawad refuses to file a complaint for violation of Barangay Protection Order, the victim survivor or the applicant can file such complaint without prejudice to appropriate administrative, civil, or criminal action against the barangay official concerned. For the appeal, a judgment of violation of a Barangay Protection Order may be appealed to the RTC, whose decision shall be final. During trial and upon judgment, the trial court where the petition is filed may multa proprio issue a protection order as it deems necessary. Enforceability of the Barangay Protection Order. The Barangay Protection Order is effective for 15 days. It is enforceable within the barangay that issued the said order.
Judicial Protection Order. The victim survivor can also ask for a judicial protection order by filing a verified protection order within the family court having jurisdiction over said victim survivor's residence. If there is no family court, the petition can be filed with the RTC or MTC having territorial jurisdiction over the victim survivor's residence. The mere fact that there is a pending application for a barangay protection order or the applicant was already able to obtain a barangay protection order does not bar the filing of a petition for protection order with the courts. Neither it will preclude the court from granting the petition for protection order. No docket fees and other fees shall be charged for petitions for protection order if the victim survivor is indigent or in an imminent danger or threat of danger. Issuance of temporary protection order. Within the court's discretion, based on the petition and affidavit attached thereto, to determine ex parte that the violent acts against victim survivors have been committed. If the court is satisfied from the verified allegations of the petition that there is reasonable grounds to believe that an imminent danger of violence against victim survivors exists or is about to occur, the court may issue temporary protection order. The temporary protection order is effective for 30 days from service on the person sought to be enjoined. Within these 30 days, a hearing to determine the propriety of issuing a permanent protection order must be conducted. Within 5 days from service of summons, the respondent may file an opposition to the petition personally verified by him, accompanied by the affidavits of his witnesses, but he cannot file the following pleadings or motions. See the list below.
Preliminary Conference. A mandatory preliminary conference shall be conducted during which the propriety of issuing a protection order will be determined. If petitioner fails to personally appear during the preliminary conference, the petition shall be dismissed unless the counsel or a duly authorized representative of the petitioner appear in court and give justifiable reason for the non-appearance of the petitioner. However, if the petition is filed for a person other than the victim survivor, it shall not be dismissed if the victim survivor is present and does not agree to its dismissal. On the other hand, if the respondent appear without counsel, the court shall not reschedule or postpone the conference, but shall appoint a lawyer to the respondent and immediately proceed with the preliminary conference. If the respondent has filed his position but fails to appear despite proper notice, the petitioner shall be allowed to represent evidence ex parte. The court shall then render judgment on the basis of the pleadings and evidence on record. Hearing of the petition. If the court find it necessary to conduct a hearing, the revised rule on summary procedure shall apply as far as practicable. The testimony of an adult female victim survivor may be taken by live link television if it appears that she would suffer trauma if she were to testify in the presence of the respondent. Likewise, the testimony of an eyewitness child may be taken by live link television if warranted by circumstances. History of respondent abusive conduct may be admitted in evidence even if the same was not directed against the victim survivor as long as it is relevant. Issuance of permanent protection order. If the court find the petition meritorious, the court will render a judgment granting permanent protection against act of violence and other necessary reliefs. The judgment ordering permanent protection is immediately executory. A permanent protection order shall be effective until revoked by a court upon application of the person in whose favor the order was issued.
Reliefs granted under judicial protection orders. A. Prohibition of the respondent from threatening to commit or committing personally or through another any acts mentioned in Section 5 of this Act. B. Prohibition of the respondent from harassing, annoying, telephoning, contacting, or otherwise communicating with the petitioner directly or indirectly. C. Removal and exclusion of the respondent from the residence of the petitioner regardless of ownership of the residence, either temporarily for the purpose of protecting the petitioner or permanently where no property rights are violated. And if respondent must remove personal effects from the residence, the court shall direct a law enforcement agent to accompany the respondent, gather his things, and escort respondent from the residence. D. Directing the respondent to stay away from petitioner and designated family or household member at a distance specified by the court and to stay away from the residence, school, place of employment, or any specified place frequented by the petitioner and any designated family or household member.
Reliefs granted under judicial protection orders. Directing lawful possession and use by petitioner of an automobile and other essential personal effects, regardless of ownership, and directing the appropriate law enforcement officers to accompany the petitioner to the residence of the parties to ensure that the petitioner is safely restored to the possession of the automobile and other essential personal effects, or to supervise the petitioner's or respondent's removal of personal belongings. And we have granting a temporary or permanent custody of a child or the children to the petitioner. Also, we have directing the respondent to provide support to the woman or her child if entitled to legal support, notwithstanding other laws to the contrary. The court shall order appropriate percentage of the income or salary of the respondent to be withheld regularly by the respondent's employer for the same to be automatically remitted directly to the woman. Failure to remit or withhold or any delay in the remittance of support to the woman or her child without justifiable cause shall render the respondent or his employer liable for indirect contempt of court. We have another one. We have prohibition of the respondent from any use or possession of any firearm or deadly weapon, and the order him to surrender the same to the court for appropriate disposition of the court, including revocation of license and disqualification to apply for any license to use or possess a firearm. If the offender is a law enforcement agent, the court shall order the offender to surrender his firearm and shall direct the appropriate authority to investigate on the offender and to take appropriate action on matter. We have also restitution for actual damages caused by the violence inflicted, including but not limited to property damage, medical expenses, childcare expenses, and loss of income. Also, under reliefs granted under judicial protection orders, we have directing the DSWD or any appropriate agency to provide the petitioner's need. We have provision of such other form of reliefs as the court deems necessary to protect and provide for the safety of the petitioner and any designated family or household member, provided petitioner and any designated family or household members consent to such relief. Any of the reliefs provided under this section shall be granted even in the absence of the decree of legal separation or annulment or declaration of absolute nullity of marriage.
Appeal. The aggrieved party may appeal the judgment by filing a notice of appeal with the court that rendered the final order or judgment within 15 days from notice. Bond to keep the peace. The court may order the person against whom a protection order is issued to present two sufficient sureties who shall undertake that such person will not commit the violence sought to be prevented. Failure to post the bond as required shall result in detention for a period ranging from 30 days to 6 months, depending on the nature of the act committed. Enforceability of protection orders. All temporary protection orders and permanent protection orders are enforceable anywhere in the Philippines.
Effect of violation of protection orders. Violation of protection orders is punishable with fine ranging from 5,000 pesos to 50,000 pesos or imprisonment of 6 months. Violation of any provision of temporary or permanent protection order shall constitute contempt of court, punishable under Rule 71 of the Law of Court, without prejudice to any other criminal or civil action that the victim survivor may file for any of the act committed. Confidentiality of proceedings. All records pertaining to case of violence against women and their children, including those in barangay, shall be confidential. However published or causes to be published in any format, the name, address, telephone number, school, business address, employer, or any identifying information of a victim or an immediate family members without the latter consent shall be liable to the contempt power of the court. Any person who violate this provision shall suffer penalty of 1 year imprisonment and a fine of not more than 500,000 pesos.
Confidentiality of proceedings. The Supreme Court has enforced this mandate of confidentiality by withholding the real name of the victim survivor, using fictitious initials to represent them and not disclosing their personal circumstances or any other information tending to establish or compromise their identities, as well as those of their immediate family or household members. Custody of children. The woman victim survivor is entitled to the custody and support of her children. Children below 7 years old or older with mental or physical disabilities shall automatically be given to the mother, with the right support unless the court finds compelling reasons to order otherwise. Leave for victims of violence. Victim survivors are entitled to take a paid leave of absence up to 10 days, in addition to other paid leaves under the Labor Code of the Philippines and Civil Service Rules and Regulations. The period of leave of absence may be extended when the necessity arises as specified in the protection order. The leave is non-cumulative and not convertible to cash if unused. The employer or agency head who denies the application for leave and who shall prejudice the victim survivor or any person for assisting a co-employee who is a victim survivor shall be liable for discrimination and violation of the law. Conditions for entitlement to leave for victims of violence. To be entitled, the following conditions must be complied with. The employee victim survivor must present a certificate from the punong barangay or kagawad, prosecutor, or the clerk of court, as the case may be, that a case for violence against women and their children is pending. And the availment of the 10-day leave shall cover only the days when she has to attend medical and legal concerns.
Interagency Council on Violence Against Women and Their Children. We have the Department of Social Welfare and Development, National Commission on the Role of Filipino Women, Civil Service Commission, Commission on Human Rights, Council for the Welfare of Children, the Department of Justice, the Department of the Interior and Local Government, the Philippine National Police, the Department of Health, the Department of Education, the Department of Labor and Employment, and the National Bureau of Investigation. These agencies are tasked to formulate programs and projects to eliminate violence against women based on their mandates, as well as develop capability programs for their employees to become more sensitive to the needs of their clients. The Council will also serve as the monitoring body as regards to the violence against women initiatives. The Council members may designate their duly authorized representative, who shall have a rank not lower than an Assistant Secretary or its equivalent. These representatives shall attend Council meeting in their behalf and shall receive emoluments as may be determined by the Council in accordance with existing budget and accounting rules and regulations.
So, to discuss further and give insights about the Republic Act number 9262, or the Anti-Violence Against Women and Their Children Act of 2004, we have with us Ms. Bernadette Andrade Nablo of the Municipal Social Welfare and Development Office of the Local Government Unit of Makato Aklan. So, Ms. Bernadette is a registered social worker and is currently the head of office of the Municipal Social Welfare and Development Office of the Local Government Unit of Makato Aklan. She is the sole social worker in Makato Aklan, handling children at risk, children in conflict with the law, and violence against women and their children cases. So, good day, Ms. Bernadette.
Good day, Ms. Nikki, and to everyone.
So, to start off, what is Republic Act number 9262 and what it is for?
So, Republic Act number 9262, or the Anti-Violence Against Women and Their Children Act of 2004, is a law which penalizes at public crime certain acts of violence against women and their children. These acts of violence are physical violence, sexual violence, psychological violence, and economic abuse.
So, who are working together to implement the said law?
To implement, we have the Women and Children Protection Desk of the Philippine National Police, the DSWD, where is the MSWDO is under, and the Barangay head, where it's Punong Barangay.
So, what is the role of a social worker in the Municipal Social Welfare and Development Office when it comes to violence against women and their children?
As a social worker at the Municipal Social Welfare and Development Office, we provide counseling, financial assistance, referral to other government agencies for additional assistance to the victim survivors of VAWC. And for cases that the victim survivor doesn't want to file a criminal case against their husband or partner, we assist them to be able to receive their settlement.
So, what are the common acts of violence you have encountered in your office?
Here in Makato, we usually encounter cases of couples, both married and unmarried, fighting. These altercations often leads to physical violence, psychological violence, and economic abuse.
What are the common reasons of these fights?
Most of the time, the reason for these fights are the drunkenness of the husband or the partner. This drunkenness often leads to the husband or the partner being what we call maoy. When drunk, then they would physically harm the women or their child. Another reason is the allegation of the infidelity of the women. Husband or partner would often accuse their wife or partner of having extramarital affair or having another lover that will usually end up to physical violence of the husband or the partner to the women or their child.
What is the process of filing or availing assistance from the MSWDO?
To avail assistance, there must be a referral from the Women and Children Protection Desk of the PNP, intake interview for our social case study report, and of course their case file when the case of the VAWC was filed. For instances that the victim survivor go directly to our office to report her partner, we write a letter of invitation for both parties. We then provide counseling. We talk about what is the cause of their altercation that lead to the act of violence. We then wait for their decision if the victim survivor would like to file a criminal case or would want other settlements.
Do you assist the victim survivor in filing a criminal case?
In my practice, yes, we assist in filing criminal cases of VAWC. We then provide financial assistance and further counseling to the victim survivor.
What are the programs or projects of the MSWDO to help eliminate VAWC?
To help eliminate VAWC in our community, we have a campaign to end violence against women and their children, which is held every November to December. We have symposiums to discuss the Republic Act 9262. We cater trainings for violence against women and children desk officers, and we have IEC campaign, or the Information, Education, Communication campaign. This campaign is headed by our Philippine National Police here in Makato. This is with regards to the Republic Act 9262, or the Anti-Violence Against Women and Their Child Act of 2004. This campaign also includes giving of flyers, which contains information about the law and posting of tarpaulins in designated conspicuous places.
So, are these programs and projects to eliminate VAWC effective? If yes, how do you say so?
Yes, these programs and projects to eliminate VAWC is effective. With regular implementation of these programs and projects, we see a decline in the number of VAWC cases. This year, number of reported VAWC cases are less compared to the previous year.
Thank you for that, Ma'am Bernadette. So lastly, do you have any message to those victim survivors of VAWC and to those who are having second thoughts on reporting the acts of violence they are experiencing?
To these victims, survivors of VAWC, be strong and keep going. Always remember to take this experience as a tool to learn and grow, and be an advocate of the campaign of a VAWC-free community. To those having second thoughts who are experiencing violence from their husbands or partners, help end VAWC by reporting them. Always remember that these are agencies that are willing to help and assist you. Let us stop the violence and be advocate of a VAWC-free community.
Thank you for that, Ms. Bernadette. Thank you for your time.
Thank you so much.